The first case to come before us this morning is Stephen Ettinger profit sharing plan versus Richard Kramer and the Goodyear Tire and Rubber Company. Both sides will have 15 minutes to argue. If you're the appellant, you can reserve up to 5 minutes for rebuttal. If you would let me know when you get started, if you'd like to reserve any time for rebuttal, that would be helpful for me as I'm keeping the clock this morning. This oral argument is being streamed live and is being recorded to be posted on the court's YouTube site. Please do not use the names of any minors or victims. I don't think that's very applicable to this case, but we like to give that admonishment before we get started. Also, if it is not your turn to argue, if you wouldn't mind muting your microphone so we avoid background noise. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. I would like to reserve 2 minutes for rebuttal.
Thank you.
Your Honor, myself and Rick Wayne represent the Stephen A. Ettinger profit sharing plan. In 2018, the plan filed a shareholder derivative action against Goodyear and certain named directors, alleging that the directors had actual knowledge of red flags and deliberately ignored and concealed safety issues regarding its G159 tire. We have discussion in our brief about the issues, in particular about the tire. I'm not going to focus on those. Instead, I want to talk about what the board did in response, because it's pertinent here. The issues in this appeal is demand futility. Rule 23.1 sets the requirement that a shareholder make a demand of a board before instituting an action so that the board can take that action itself if it chooses to. The rule also allows demand to be excused if it is futile. Plaintiff here did not make the demand and instead set out allegations in the complaint as to why making the demand on Goodyear here was futile. The trial court dismissed the plaintiff's complaint in response to the defendant's motion to dismiss and addressed only demand futility. And in particular, a couple of things the trial court included in its order were that it required director by director allegations of how that director would be conflicted or interested in this matter, and looked solely at the issue when you get to a conflict or interest of director compensation. Those were not necessarily the focus of our complaint, and certainly not the focus of the pleadings in the trial court. Plaintiff submits that the trial court did not properly analyze the demand futility requirement and that instead the complaint satisfies the law. Demand is futile here because the directors of Goodyear turned a blind eye to the red flags that revealed fraud and concealment of a defective tire. This was concealed from government regulators, from courts, and from litigants. This resulted in sanctions against the company, pending regulatory investigations that could still result in very large sanctions. The red flags, Your Honor, that are alleged in the plaintiff's complaint with particularity were known to the directors. There were hundreds of property damage and personal injury claims and lawsuits, including deaths. There weren't hundreds of lawsuits, but there were a lot of lawsuits, enough that required Goodyear to hire National Coordinating Council to manage all of the litigation. This litigation was replete with protective orders and confidentiality agreements, causing one judge who was reviewing one of the cases to comment that these confidentiality measures insisted on by Goodyear prevented any court from adequately assessing the risk posed by this tire. The only party that could, of course, do that was Goodyear itself. There was in the G159 tire litigation at least one jury verdict, resulting in a $5.6 million award against the company. There, in one case at least, was crucial evidence that was hidden and concealed from the litigants and from the court in that case. That resulted in a separate lawsuit. That's the Hager case, which challenged the hiding of this evidence. That challenge in the Hager case resulted in a blistering opinion from a federal judge in Arizona that excoriated Goodyear's associate general counsel and its National Coordinating Council for what it described as misleading and false statements, and for a deliberate attempt to mislead the court and the litigants. The court in that case also found that Goodyear's corporate representative's testimony was false and was compounded by a false declaration. The court noted that any responsible corporation would not allow this to happen, and found that Goodyear, quote, participated directly in the fraud. This misconduct extended into the general counsel's office, resulted in a sanctions award of $2.7 million, and that was appealed all the way to the Supreme Court of the United States and resulted in a U.S. Supreme Court opinion. In 2018, some of the evidence in that Hager case was unsealed, collected by a media outlet, and reported extensively. That evidence, for the first time in 2018, revealed that general counsel at Goodyear had approved all of the requests for settlements in the tire litigation, and that he attended all of the board meetings. Richard Kramer, who was then the president of North American operations for Goodyear, he had ultimate authority over the G159 tire. He would later become a director and a CEO and the chairman of the board of Goodyear. He had personal involvement with the G159 tire issues. He approved confidential settlements, and this test data that was concealed in the Hager case had been communicated to him by the associate general counsel, who was sanctioned by the court in Hager. That same counsel made a presentation to the board of Goodyear, including Mr. Kramer and a majority of the current directors. And that presentation was made, this was about the G159 tire litigation, and that presentation was made at about the same time that the evidence was being concealed in Hager. There was also other red flags, were that there was a defect investigation by the National Highway Transportation Safety Administration, which is, of course, a regulator of Goodyear. That investigation is still open, and the fines are still possible in that investigation. Goodyear, this conduct spans a course of about 15 years. Goodyear and its directors have plenty of time to analyze and respond to these red flags, but they did nothing. Rule 23.1, of course, states a demand futility requirement, but it doesn't state how to analyze demand futility. And the Ohio Director Liability Statute that's relied on by Goodyear here, which is 1701.59E, doesn't instruct on how to analyze demand futility either. Instead, it sets the standard of liability for a director ultimately. And a reversal here, Your Honors, is not going to result in liability on Goodyear's part. It's just going to send the case back to the trial court for discovery. To analyze demand futility, the courts in Ohio have looked to Delaware cases for that analysis because they have a lot of experience in analyzing that issue. Those cases and this tests are stated in our brief. The lead case is the Aronson case. That's been relied upon by Ohio courts. It was cited in the Draghi versus P&G case, which is cited by Goodyear and was cited by the trial court, was also cited in Doe versus Malkoff, which was also cited by the trial court. Under Aronson, here in this case, demand is excused because plaintiff alleges particularized facts creating a reasonable doubt, that's the language in the standard, that the directors were disinterested and independent of the company's handling of the G159 tire issue. And also because the particularized allegations create reasonable doubt that how the company handled that issue was the product of a valid exercise of business judgment. There's a Carlson case that comes from the First District in Hamilton County, 2003, states a similar requirement in a little bit of a different way. There, the court said that futility means that the directors' minds are closed to argument and they cannot properly exercise business judgment in determining whether the suit should be filed. Here, Your Honors, the allegations in our complaint are that the board was aware of these red flags. They're alleged with particularity in plaintiff's complaint and established that for at least a majority of the board members, their minds were closed to argument and could not properly exercise their business judgment in the handling of these issues related to the G159 tire issues. The majority of those directors chose to do nothing when these red flags were waved before them, despite the fact that they were all operating in a highly regulated industry where product testing and potential defects have to be reported to the government. Majority, as I said before, these directors were directors in 2010 when this presentation was made to the board and were briefed on these issues. They were briefed by the same associate general counsel that was later sanctioned in Hager. They were briefed at the exact same time that the evidence was being concealed in Hager. And they were being briefed at the exact same time a court later found that Goodyear was directly participating in fraud. They were briefed also while Mr. Kramer was on the board. He was a director and CEO at the time, and he had personal involvement in these G159 tire issues in his prior role at the company. A majority of the directors have served on the two committees that are responsible for monitoring these legal and compliance issues. The audit committee, 5 of the directors serve on the audit committee, which is specifically charged with monitoring fraud and risk management in the company. That committee should have met 50 times during this course of conduct.
Counsel,
yes.
Counsel, I'm going to ask you somewhat of a preliminary question before we get too close to the end of your time here for argument. There seems to be some disagreement on the standard of review for this court. I know that you indicated that the standard of review is de novo. Counsel for the other side indicates it's either de novo or abuse of discretion and continues to argue from there. Can you talk about why you believe this is a de novo review?
Certainly, Your Honor. The two cases that are cited are the Draghi case, Draghi versus Procter & Gamble, and the Lubrizol shareholders litigation. The Draghi versus Procter & Gamble case is the one cited by the defendants for the proposition that de novo is abuse of discretion. In that case, Your Honor, there was not an analysis of the standard of review. In fact, the case recites that the parties agreed that that was the standard of review. We don't agree with that here, Your Honor. I think this is a motion to dismiss that should be treated as other motions to dismiss are treated by the Ohio courts, and that is reviewed de novo, which is essentially the analysis that the Lubrizol court arrived at. So although Draghi is cited for that proposition, Your Honor, I don't believe that that was actually litigated or analyzed at all in that case.
Thank you.
So continuing on, Your Honors, these red flags, as we've alleged, the media disclosures about the conduct, the litigation all the way to the Supreme Court, the fines, the sanctions, all of this conduct, all of the directors should have been particularly hawkish about stopping this and preventing the concealment when they became aware of it, but they did nothing. Two cases that I'd like to talk to the court about that are instructive here are the Cardinal Health cases. Cardinal Health was a large distributor of opioids and had a lot of regulatory and legal issues surrounding its distribution. And like Goodyear, Cardinal operates in a highly regulated environment. The first Cardinal case is the one cited by Goodyear, which is the Stanley versus Arnold case. That's a 2012 decision from the Southern District of Ohio. In that case, the court held that the plaintiff had not established that demand was futile. Although red flags were alleged, the court noted the plaintiff did not allege that directors were aware of any of those red flags. There were no particularized allegations that they knew of those. That conduct that was challenged there occurred during a 2-year period. The second Cardinal Health case was very similar allegations, comes along and was just decided in this year, in 2021, also out of the Southern District of Ohio. There, the court found that demand futility was established. The plaintiff alleged there, like we do here, the plaintiff identified the red flags, alleged the board members knew of those red flags, that they came to their attention, that they ignored them. The plaintiff alleged the various committee assignments of the directors and the requirements and the responsibilities of those committees. and the known regulatory actions that the board was aware of or should have been aware of. That
And
conduct.
Counsel, you're at that 2-minute mark. You can reserve or continue.
Your Honor, the second Cardinal Health case is much more indicative of the facts of this case, given the long period of time and the allegations that the plaintiffs make. For those reasons, we would ask that the court reverse the trial court and conclude that demand futility has been adequately alleged in the complaint. Thank you.
Thank you, Counsel. Counsel for the appellee. You already did unmute yourself. You're ahead of the game. Thank you.
Good morning, Your Honors, and may it please the court. Marjorie Duffy of Jones Day on behalf of the individual defendants in this case, who are certain current and former directors of the Board of Directors of Goodyear. Mr. Fairweather of Browse McDowell is here on behalf of nominal defendant Goodyear. Mr. Fairweather and I have conferred, and I will be presenting on behalf of all defendants for the entirety of our allotted time. Your Honor, the district court was right to dismiss the complaint that plaintiff seeks to revive here. There are two separate bases to affirm. First, the complaint was not properly verified as required by Civil Rule 23.1. Second, plaintiff's failure to make a pre-suit demand was not excused as futile, and therefore plaintiff lacks standing to assert claims that belong to Goodyear. For the first point about verification, plaintiff's original verification was patently inadequate. Even after defendants specifically identified the deficiencies in the first verification, plaintiff's second attempt still fell short. I will rest on our papers, Your Honor, unless the court has any questions. As to the second question here and before the trial court is this: whether the complaint pleaded particularized facts showing that at least 6 of 12 directors are substantially likely to be found by clear and convincing evidence to have deliberately intended to harm Goodyear or have recklessly disregarded its interests. The demand futility question reflects foundational principles of corporate law. It respects the board's authority under 170159A to manage the business and affairs of the corporation. That statutory authority includes making decisions as to whether to assert a claim that belongs to the company. It is also the responsibility of the board to determine whether to cause Goodyear to assert one of its claims. The question of demand futility acknowledges that the board is also statutorily presumed to act in good faith. It also accounts for Civil Rule 23.1, which requires particularized pleading. There is no dispute here that pleading demand futility is not an easy task, nor is it a mere technical requirement. Rather, it requires the plaintiff here, who owns some handful of the 230 million outstanding shares of Goodyear stock, to identify specific facts as to specific directors, to give reason to displace the board's statutory authority to manage the company's business and affairs. The demand futility question also accounts for the express statutory limitation on director liability under Ohio law. In this regard, Your Honors, Ohio law is meaningfully different than Delaware law in this respect. Unlike Delaware, Ohio's corporate statute sets a definitive and strict standard for director liability, which is an intent to injure the company or a reckless disregard for its interests. And it also requires an elevated standard of proof, which is clear and convincing evidence. Ohio law does not recognize liability for directors based on allegations of negligence, no matter how particularized. Your Honors, plaintiff relies on cases from Delaware regarding the Aronson case, the Aronson test, and the papers also set forth their position with respect to rails. Your Honor, as we pointed out in our papers, the distinction here is irrelevant. The reason plaintiffs seek refuge in Aronson is because they're trying to escape the director liability standard of substantial likelihood of liability, where we have that elevated standard of proof and definitive standard of conduct. There is no doubt, Your Honors, under Aronson or Rails and under Ohio law, which applies here, that the question is one of substantial likelihood of liability with particularized pleading, proven by clear and convincing evidence with an intent to injure or reckless disregard. Your Honors, plaintiff waived a number of arguments and claims in the trial court and now seek to resurrect those here. In particular, with respect to the red flags argument, this is ultimately what's called a so-called Caremark claim. This is a claim for director liability oversight. Now, plaintiff made very clear in the trial court that this is not a Caremark case and that they are not pursuing a Caremark claim. Nevertheless, the red flags argument and the inferences that plaintiffs seek to draw regarding director knowledge, which are inconsistent with Ohio law, that ultimately is a Caremark claim simply by another name. I'll address, Your Honor, the so-called red flags that plaintiff has identified, but I also want to acknowledge that the plaintiff's case under the two prongs of Caremark fall short under either. First, even if not waived, the plaintiff has failed to satisfy the first prong of Caremark. Caremark requires that the directors utterly failed to implement any reporting system or controls. As you just heard, the board had committees. The plaintiff specifically alleges that those committees met regularly and that the directors received reports. Of course, the contents of those reports are totally unspecified, and there are no allegations as to what the directors were told or believed or did or did not do in response. So we have the first prong of Caremark, even if not waived, is off the table. Plaintiff's second argument relies on this red flag theory. And I'll note here, picking up on Mr. Sparks's presentation regarding the Cardinal Health cases, the recent Cardinal Health case really stands in stark contrast to the allegations in this complaint. And that's important because, again, the standard requires particularized pleading. It is not sufficient under Ohio law to infer knowledge based on directors. There must be specific allegations showing that red flags were actually known to the directors, and then specific allegations as to what the directors did or did not do in response. In the Cardinal Health case, Your Honors, there were numerous specific facts that were pleaded in the recent one. This is the 2021 decision that was issued, we'll call it the second Cardinal Health case. The first one is the Stanley case that was affirmed on appeal by the Sixth Circuit. The first Cardinal Health case is much like this one. The second one alleges numerous facts that appear nowhere close to those alleged in this complaint. There, the plaintiff sought books and records, unlike the plaintiff here. The books and records were reviewed, and the allegations drawn from that review of books and records of account under Ohio law allowed the plaintiff to allege no fewer than 53 specific instances where issues were discussed with the board. There were things including reports to the audit committee that had specific allegations regarding the contents of those reports. There were numerous meetings that were identified, and there were sufficient particularized allegations that allowed the court there to conclude that, unlike here, and unlike in the Stanley case, the first Cardinal Health case, that the directors had been sufficiently alleged to have actual knowledge relating to Cardinal's health compliance issues in that case. Here, there's nothing remotely similar. Plaintiffs seek to build an inferential chain that is weak from the outset. They pile inferences upon inferences. Your Honor, you heard plaintiffs, and of course saw in the briefing, there's substantial discussion of a consumer products liability case and the lengthy history relating to that. Your Honor, what you didn't hear in either Mr. Sparks's presentation on behalf of plaintiff and what you didn't see in the complaint or any of the briefing are any specific allegations tying any of the discovery misconduct in that case to the board. You didn't see any allegations reflecting that the board believed that there was any issue, for example, with reporting requirements. You didn't see any allegations suggesting that anyone in the company's in-house legal department told the board that there were problems with the G159 tire and ignored those problems. Or you didn't see anything reflecting that there was any information provided to any of the directors at any time that would show that the directors actually knew that there were problems, and then they, quote unquote, chose to turn a blind eye to them. The complaint simply does not allege that. The fact that there was litigation, and there certainly is, of course, much like every company, a consumer products company like Goodyear faces many lawsuits. The complaint alleges that there were as many as 40, not hundreds or more, that there were 40 lawsuits. One of those was tried to a verdict in 2010. Mr. Sparks, there was, I think, a little bit of a confusion on the chronology. That was the first Hager case that was settled, excuse me, the first case, the Shalmo case, was the one that was tried to verdict. The Hager case was settled in 2010. There were no sanctions that were issued until 2012, after the 2010 presentation of unspecified content, and I'll come back to that in a minute. In 2012, the court in Hager sanctioned the company and its lawyers and did conclude that one of the in-house lawyers had not, and the outside counsel had not produced certain information. That sanctions decision did not find that any of Goodyear's directors had been involved in any misconduct. In fact, it didn't even mention any of the directors. The sanctions proceedings have now concluded after, as Mr. Sparks indicated, a trip up to the Supreme Court and back. In the state court Hager proceeding, there were arguments there relating to unsealing of documents. And in that, after an appeal, the trial court determined those documents should remain sealed. The documents were determined to be trade secrets, and the court specifically concluded that maintaining the secrecy of the documents does not represent a significant threat to the public welfare. The court made specific findings, including that Goodyear's interest in maintaining confidentiality over its trade secret information overcame the right to public access, found that there would be a substantial likelihood that Goodyear would be prejudiced if its trade secrets were revealed in the public, and found that the restricting access was sufficiently narrow in light of the public interest. The court specifically concluded that maintaining the documents under conceal is the most reasonable and least restrictive alternative to preserving confidentiality. There were no findings, again, against any of the directors. The directors were not even mentioned, and there was no finding of any sort of improper cover-up. Your Honors, I mentioned that the 2010 settlement memo that is featured in the complaint. And I note featured because it is frankly really one of the only allegations that is specifically directed at the directors at all. The complaint alleges that in 2010, a presentation was made to the board by one of Goodyear's in-house counsel regarding the G95 litigation. It's important to note what's not in the complaint. Nothing about the contents of the presentation. The complaint doesn't allege that this in-house counsel or anyone else told the board in 2010 or at any other time that the tire was defective, or that there were problems, or that there was merit to the product liability suits. There were no allegations in 2010 by this in-house director or anyone else had ever told the company that there was any problem with their reporting requirements. And worse, the complaint never says what the board did or did not do in response. Your Honor, I see that my time is drawing to a close. I think that the fundamental failure of this complaint is the total lack of particularized allegations that any of the directors, far less 6 or more, are substantially likely to be personally liable, to be found personally liable by clear and convincing evidence, to have intended to harm Goodyear, or to have recklessly disregarded its interests. Your Honors, I also note that with respect to the statute of limitations argument, that also has been waived at the trial court, and the total lack of allegations relating to any events that are of more recent vintage, that simply bolsters the conclusion that there are simply no particularized facts pleaded here to support a finding of demand futility. Your Honor, the decision of the trial court should be affirmed and the complaint should be dismissed. Thank you.
Thank you, counsel. Mr. Sparks, you have just over 1.5 minutes remaining for your rebuttal. You will need to unmute your microphone.
Sorry, thank you. Your Honor, briefly on the verification and statute of limitations issues, those issues were not decided by the trial court. That was not at all a part of the opinion. It dealt with demand futility only. The Cardinal Health case, Your Honor, there's some conflation of a Caremark standard versus just a demand futility standard. And if you look at the Cardinal Health case from this year, the red flags that Goodyear says are only present in Caremark cases, that's simply not the case. That was a prominent part of the Cardinal Health case and the other cases that deal with demand futility. Which is why we focus on them in the complaint. I want to talk about this 2010, this meeting of the board that is alleged to not really have any import here. So the argument from Goodyear appears to be that the general counsel who had, or the associate general counsel who had the most direct involvement in this litigation shows up, and at the point in time when they're dealing with the litigation. We later know the company had concealed evidence. They were concealing the evidence from the litigants at that time that she gave the presentation. And there was clearly a problem with the tire. The Goodyear would have you believe that that associate general counsel showed up and did not brief the board on any of these issues. That's simply, I don't believe, if that is what happened, then there was really a problem at Goodyear. But instead, what we know is that she had direct knowledge of these issues. The CEO and director, Mr. Kramer at the time, also had that same direct knowledge, if not more.
And counsel, you're going to need to conclude now because you have utilized your rebuttal time.
Thank you, Your Honor. That's all.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website. We are adjourned until our next video oral argument on Tuesday, July 6th. Thank you again. Have a wonderful day, counsel.
Thank you, Your Honor.
Thank you, Your Honors.